We are set for a pretrial conference. It appears we have a resolution in this matter, Mr. Carnes.
Yes, Your Honor. It's my understanding the defendant will be pleading no contest as charged.
Ms. Jones, have you heard what the attorneys have said the resolution in this case is?
Yes.
And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? Ms. Jones, it's my understanding that the agreement today is that you will plead no contest to assault and/or assault and battery. Now, along with that, there's what's called a Killebrew agreement. And what that is the prosecution and your attorney and you have reached an agreement that you'll be placed on a delay of sentence. And if you're successful with that delay of sentence, the case would be dismissed. If I decide that I do not want to go along with that agreement, you have the option to withdraw your plea. Do you understand that?
Yes.
Then, Ms. Jones, to the offense that on or about March 31st, 2025, here in the city of Cadillac of Wexford County, how do you plead to committing the offense of assault and/or assault and battery upon Courtney Elaine Whaley?
No contest.
I've had the opportunity to review the People's Exhibit number 1. I find the plea is knowing, voluntary, and accurate. As such, Ms. Jones, I find you guilty of assault and/or assault and battery. In particular, on March 31st, 2025, there is a video that shows Ms. Jones hitting, kicking, kneeing as the victim is lying in a fetal position by the old, what's commonly referred to as the old dam. The court can take judicial notice that is located here in the city of Cadillac. The victim is a 14-year-old middle schooler. The victim reported that she had no injuries. It is alleged in the police report that Ms. Jones posted another video on TikTok captioned Round 2. And this appeared to be all over some things that were said about another's deceased mother. As such, I find that the elements are made out for an assault and battery, and that this would have been an unwanted, forceful, violent touching. Additionally, I believe the interests of justice are well established here in allowing the defendant to plead a no contest so as to not have her guilty plea used against her should a case of civil liability arise, although I question what the civil liability would be since there's no injuries, but I guess that's not for me to determine. Mr. Carnes, are we able to sentence today?
Yes, Your Honor.
What I will say is my client has, to my knowledge, done well on bond. She stayed in constant contact with the defender's office, been very cooperative. She does have strong ties to the community. I don't doubt she'll do well on probation. She's highly motivated to do well and receive the benefit of the delay.
I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement. She's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground because of something that was said about somebody else's deceased mother, and then had the gall to post another video of it on TikTok. That's not somebody who's making a mistake. That's not what this type of thing is designed for. A delay of sentence is to allow the court to determine whether or not the person will be successful on a term of delay in sentence, and hopefully follow through with the plans. From what I've seen from Ms. Jones, this is not a one-time mistake. Ms. Jones has been in and out of this, whether it's this court or the probate court, or somehow tied with other events. I'm not going to make a decision today. What I'm going to do is I'm going to set this over for sentencing, and I'll allow both parties the opportunity to do sentencing memorandums and try to convince me why I'm wrong in my thought process. But as I sit here today with the information I have, I cannot in good conscience let this just get, for all intent and purposes, swept under the rug. But as I said, I will allow the opportunity for some briefing or some sentencing memorandums to be done. And I realize, Ms. Jones, I had not given you the opportunity to allocute yet, but we will adjourn sentencing and allow that to happen.